Appeal, Butthead, CRF I Ltd and Banco Nacional De Cuba and another.
Good morning.
Good morning, my lady.
Not quite as early as intended, but not as late as that clock suggests.
No. We have a few more minutes at least, and we're grateful for that. My lady, my lords, at the close of play yesterday, I had reached the section of the judgment in which the judge was addressing Mr. Lozano's email of the 22nd November 2019 and his formal letter of the 25th of November 2019. And I had drawn the court's attention to paragraph 331 on page 148 of the core bundle, where the judge recorded that such November correspondence was not in analytical terms relevant, but she said at paragraph 331 that she would nonetheless consider what impact, if any, arguments of Cuban law as to formalities had on those documents. And I noted that what the judge said at paragraphs 332 to paragraph 334 on page 149 of the core bundle as to where in the process described in the BNC handbook the requirement for two signatures was mentioned. It was mentioned at the later materialization stage, not at the earlier consent in principle stage. And thus, I noted that the judge had found at paragraph 335 that even if there was a requirement for such signatures at the materialization stage, it could not affect the validity of the 13th of June consent. And that, as I submitted yesterday, reflected her earlier findings in paragraphs 227 to 228, and what I described as the important paragraph at 246 of her judgment. So if the BNC signature rules could have been engaged at all, then on the judge's findings, they could have been engaged only in relation to the analytically irrelevant materialization stage. And as to that, the judge considered whether the November documentation constituted a banking operation within the meaning of the BNC signature rules. And at paragraph 336 on page 150 of the core bundle, she found that they did not. Starting at the beginning of the third line, the judge said, "It is hard to see why, if consent does not, as I have concluded, constitute a banking operation caught by the rules, this materialization stage would. Looking at the way in which such a document, that's the 25th of November 2019 document, would fit within the scheme of the rules, there is no easy fit. Such a letter is not covered by Article 12. I'm sorry.
It's entirely my fault for momentarily forgetting, but can you remind me what the 25th of November letter actually consisted of?
So the 25th of November letter consisted of both a letter from Mr. Lozano written to CRF confirming that the assignment had taken place. And attached to that, there was the assignment itself,
right,
which had been stamped and signed by Mr. Lozano.
Right. And on this appeal, the validity of the assignment is not an issue. The issue is prior consent. Is that right?
The issue is prior consent. And what is said is that the judge's conclusions in relation to prior consent were wrong because the prior consent, the email of June 2019, should have been signed with two signatures. And the route they get there is through the BNC signature rules and Article 15L of those signature rules in particular.
But I think that...
But the conclusion they draw, because there was no prior consent given, no valid prior consent given, is that the assignment was not valid.
But the point I think my lord was making, I'm sure he's perfectly capable of making it himself, but it is that therefore all the focus is on the consent And none of it is on the actual validity, in inverted commas, of the assignment. Yes,
Absolutely.
which is-
Exactly
absolutely.
right.
Precisely.
On this appeal, yes.
Thank
At trial, one of the points the judge makes is all
At trial, there were a host of issues which
Yes.
fortunately win.
yes, yes.
Yes.
But the reason I'm drawing the court's attention to this paragraph is the judge's analysis in relation to the later document is relevant to her analysis in relation to the earlier document, which is in issue. And what the judge is looking in relation to the irrelevant later document, what she says, is hard to see why if consent, that's the prior consent, does not, as I have concluded, constitute a banking operation caught by the rules, why this materialization stage, the irrelevant document, would. And she explains, looking at the way in which such a document, the later document, would fit within the scheme of the rules, there is no easy fit. Such a letter is not covered by Article 12, banking transactions creating an obligation. As a formal approval of an assignment, it does not happily fit within Article 15D, which provides to issue any comfort letters and guarantees, or within Article 15K, to approve any accounting vouchers and notices related to any of the above transactions, or 15L, authorising and executing any other banking operation in accordance with international standards. So the judge, in relation to the analytically irrelevant document, had well in mind all of the provisions of the BNC signature rules that were relied upon by BNC, specifically Article 12 and Article 15L. And the judge's conclusion, as I say, in relation to the former letter, was that it was not a banking operation for the purpose of the BNC signature rules, and that as such, the absence of two signatures on that document did not affect its validity. And the judge was fortified in this view by the seemingly practical irrelevance to BNC of the fact that the 25th of November 2019 letter had been signed by Mr. Lozano alone. And that's paragraph 341 of the judgment on page 151. In the second sentence of paragraph 341, the judge says that even internally, it would seem that any irregularities with respect to the number of signatures on the 25th of November document, the former letter, were in practical terms irrelevant in that the assignments were registered and were given an assignment number, as evidenced by the table of original assignments extracted from BNC's debt assignment registry maintained on Miss Marty's computer. And that is a reference to the very end of the materialization process, as described in the BNC handbook, a reference to which we saw yesterday when the judge set out the extract on page 93 of the core bundle. But later on, also in paragraph 348.6, Roman 6, on page 153 of the bundle. Paragraph 348 starts on page 152. But in subparagraph 6, on page 153, when addressing the BNC working group's consideration of CRF's letters before action in the context of the ratification issue, the judge concluded as follows. Even as to the 25th of November letter, no one seems to have raised the question of defects in the documents rendering the consent to this assignment invalid. The judge said that if, as is accepted, the working group looked at least at the 25th of November letter, and if, as BNC contend, everyone knew about the two signature requirement, there is an interesting lack of explanation as to why this was not raised. This lack is, of course, consistent with my primary conclusion on prior consent and actual authority. And she continues, but on the hypothesis that there was no actual authority, it would seem to follow that none of them considered the point worth raising. So the lack of explanation as to why the absence of two signatures was not raised in the working party deliberations is consistent with the judge's primary conclusion that the formal letter of the 25th of November 2019 was not a banking operation caught by the BNC signature rules.
Yeah, now I apologise for again asking questions that I should know the answer to. But as you explained earlier, the relevance of the 25th November letter is because it's expressed to be confirmation of agreement to the assignment. And we know that was signed by Mr. Lozano, that he was the only signatory, and hence the issue about that letter. But the assignment itself, am I right in thinking that had two signatures on it? But because I'm trying to find a finding on that, but I couldn't find it.
The assignment itself was signed by ICBC with two signatures and by CRF with two signatures. But,
yes, of course,
but
they weren't, because they were the assignors.
Assignors and assignees.
Yeah.
And it was confirmed as having been seen by BNC, and it was registered in BNC's debt registered, but with only one signature by BNC.
Right, yeah, understood.
And a stamped seal of BNC. Now,
Which was in accordance with the practice that we looked at yesterday.
not the practice we looked at yesterday said in relation to this materialization stage, the November letters,
Yes.
there would be two signatures.
Right, okay.
And it's that point that I'm coming to.
Hence the point about, quotes, Mr. Lozano's mistake.
Yeah.
Exactly.
Got
Exactly.
it.
So the judge's conclusion is that internally, according to the BNC handbook, there should have been two signatures. There was only one signature,
Yeah.
and yet no one in BNC responded to that. Either Ms. Marty, when she registered it in the debt of registry at BNC, nor the working group when they looked at the document in response to the letters before action. No one said there's only one signature, there should have been two, and raised a point about it.
But what are you saying is the significance of that?
The significance is because it forms part of the judge's reasoning that I'm going to come to in a moment in relation to her assessment of the prior consent letter and Professor Mendoza's evidence in that connection.
But it can't be relevant, can it?
The same.
The fact that later individuals who aren't, as I say, lawyers, didn't spot the problem, how is that relevant to the legal issue we're concerned with?
Well, only in this sense, my lord, and it's the way that the judge put it, is she concluded that the signing of the letter of the 25th of November did not fall within the meaning of a banking operation for the BNC rules. And she was fortified in that view because no one responded to it. That was the point she was making.
But again, I ask, why is that relevant?
Well, it's a sense check for the judge. She was performing a sense check, and it comes to this. Maybe if I make this point, the question, or what followed from the judge's conclusions as regards the requirement for two signatures on the documents at the materialization stage, that requirement was not derived from the BNC signature rules.
It's derived from the handbook.
Exactly. As to why the BNC handbook referred to two signatures at the materialization stage, the judge considered that as well at paragraph 334 of her judgment. Starting in the sixth line down, towards the end of that sixth line, the sentence beginning, it is not clear. It is not clear, even after the evidence, what the precise basis for the reference to two signatures in the BNC handbook is at the materialization stage, or why, as a matter of law, there is a requirement for two signatures in that context. That requirement is not communicated to the assignor or assignee as a requirement for consent. It comes without ever having been notified to the assignor or assignee at a stage after that they have been given consent in principle. Logically, it appears to be a combination of a tidy system for BNC records and some form of comfort to the assignor and the assignee.
Well, I mean, as you say, these are all interesting questions, but the key point, as you pointed out at at the end of yesterday and the beginning of this morning is what she says in 335 is, okay, well, even if there was a requirement for signatures at that stage, it doesn't matter.
Yes.
Because the requirement is simply for prior consent. There's no requirement in the clause for a signature at all. The email doesn't contain a signature. No formalities at all are required, and there's a finding of fact that was consent, and that finding of fact isn't challenged, and therefore everything else is actually academic on your argument.
My Lord puts it ever so concisely, and I am...
Do you have to grapple with paragraph 337 as well, though?
that if, contrary to the above, it did form a banking operation.
Yes. Because that's the appellant's argument.
Well,
The
337...
last sentence, isn't it, that's important?
Well,
Because that argument would apply to the 13th of June letter as well.
well, again, as I explained yesterday, accepting that the argument would apply to the 13th of June email, it comes back to the point that I made yesterday, that there is a delegation of authority to officials of BNC who are appointed to positions, and they are authorised to carry out tasks within the scope of their delegated authority. And the BNC signature rules, that I'm going to come on to submit in a moment, are directed to signatures in relation to banking operations and give, for example, Mr. Lozano an authority to sign documents or approve actions by BNC which go beyond his delegated
This is what you told us yesterday.
It is.
Yeah, and it comes back to the point that I was asking Mr. Dudnik about, which I was puzzled, which is that when you look at 302 and 303, the parties' respective cases, they seem to be like ships passing in the night. And that actually fits with your submissions, because you say, well, the judge accurately sets out in 303 what our case was, and it was all about who has the authority. It's not about signatures at all.
Correct.
Whereas the defendant's argument is all about looking for a signature and then looking for a rule about signatures.
Correct.
And your case is, well, even if all of that stuff about signatures is correct, it's simply irrelevant.
Correct.
And that also turns on whether the consent was a banking operation.
Yes. So
And that's the nugget.
So we have two answers, or at least the judge had two answers we submit to BNC's case on how Miss Marty was to go about exercising her authority to give prior consent. The first was that the BNC signature rules were entirely irrelevant to Miss Marty's email of the 13th of June 2019, as there was no signature requirement imposed on the giving of such prior consent. The second answer, which is apparent at the moment, at least in the course of her treatment of the analytically irrelevant formal letter of the 25th of November, the second answer the judge indicates why the BNC signature rules had no role to play was that the giving of prior consent by Miss Marty by her email of the 13th of June does not in any event constitute a banking operation caught by the BNC signature rules. So just as there was no easy fit for the formal letter of the 25th of November within the scheme of those rules, which is what the judge found at 336, including Article 12 and expressly Article 15L, there was likewise no easy fit for the earlier consent in principle.
Slight difficulty I have with the way you're approaching this, if I may say so, is I quite understand why you're taking these paragraphs, but one has to consider all these paragraphs in the context of what she has said, paragraphs 321 to 328, and by excising those from your analysis to this point, I think it slightly perverts the sense of what she's saying.
Well,
And so, I mean, I understand you want to cut and salami slice it, but we do have to understand that this has to be looked at as a whole. And at the moment, I'm having some difficulty understanding how you rationalise what she says in 321, 322, and in particular 328 and 329. I think, can I just say one of the things that
Yes, please.
I'm finding difficult at the moment is that it seems to be there are two related but different points which are being addressed at the moment. One is, what is the right answer? But there is a prior question, just like there's prior consent, of what did the judge decide? And it seems to me that the first thing we have to ascertain is, what did the judge decide? Then we have to look at was that right or not, and whether or not what she decided is the subject of appeal. And at the moment, it seems to me your arguments are crisscrossing those two issues skillfully, I'm sure. But I, at the moment, am at each point I'm thinking, well, does that go to what the judge decided, or does that go to the right answer? Does that go to what's being appealed? You see what I mean?
I do, and may I say, I have not sought to excise the key paragraphs of the appeal. I'm coming to them directly now.
I'm not saying you've excised them, but you have danced round them so far.
I have, to give the court, as much as I can on this appeal,
Yes.
a full understanding
Yes.
of the judge's thinking in relation to this issue as a whole.
But can I understand this? Do you accept, or do you disagree with this proposition, that what the judge has done here is not clear?
I disagree with that proposition.
Well, I really appreciate understanding what you say she did. At the moment, it's not clear to me.
So my Lord, let me address that head on. My submission is that, looking at the judgment, she has made a finding
Yes.
that there was no need for any signatures in relation to the prior consent that was given by Miss Marty in June 2019. And the way that's expressed...
You say that's 246.
Well, I say that is the absence of formalities in relation to the June 2019 email is apparent from paragraph 227, start there, 227 and 228 of the judgment. Having recorded in paragraph 225 that the email was sent, Ms. Marty's June email was sent. At 227, the judge recorded there was nothing unusual about that email, the sending of an email.
Yeah, and she goes on, importantly, in 229 to say that there was a disagreement as to which was the relevant document for prior consent, because you were saying it was the 13th of June, whereas the defendants were saying, no, it's 22nd or 25th November. Those are the relevant documents. And the judge's answer at 230 is that you're right, the relevant document is the 13th June one.
Precisely. And in relation to the 13th of June one, there was no formalities required. There was no... And that is the point that's then picked up. Having set out the handbook and having set out Mr. Lozana's confirmation that the sending of the emails, sending emails giving prior consent, was standard practice or pro forma. She then comes at 246 specifically to address the argument raised by BNC. An argument was also deployed by BNC by reference to the supposed need for two signatures. That's an argument as to formality.
Yeah, I'm sorry, I was at 231 and 232 about no formalities, and
Yes.
then you had gone on, and I had failed to paragraph.
246,
Thank you.
what I described as the important paragraph on page
The
128.
difficulty with it at this stage, and I accept that's what she says, but at this stage she hasn't considered the arguments relating to section 15 and section 17. And she's only considering the handbook at this stage. and she says there is no document or evidence which suggests that two signatures were ever required. Well, that's not right, because it's being said very clearly that Article 15 and Article 17 require two signatures, and she expressly records that that's the argument at 322. So I have real difficulty in saying that is an argument, that is a finding at 246 that determines that there is no requirement under articles pursuant to sections 15 or 17 for two signatures, because it just hasn't been addressed at that point. And then when she comes to address it, she says in 320, as you say, she says there's delegated authority, but she says, subject therefore to any requirements as to how they were to go about performing actions pursuant to their authority. And then she says, are there any requirements of Cuban law which go to their actions on the 13th of June? So that couldn't be clearer, could it? That she doesn't say at that point that this is all irrelevant, and I'm looking at this in the alternative. It's part of her ratio that she says, delegation, but are there any requirements? Are there any requirements as of the 13th of June? And she says, defendant says, 15L, the question is it a banking operation? And then she goes on to consider whether it's a banking operation and finds, and the appellants obviously say she got this wrong because she misunderstood the evidence, and concludes that consent to an operation is not a banking operation, thus there is no need for two signatures.
Yes.
Well, none of that is caveated or conditional or expressed to be subject to what she's said at earlier stages, and it's the only time she considers whether or not Article 15L applies to the 13th of June letter. And despite all you said about 246 before and what she says about the 20th of November, this is clearly, on the face of it, her ratio as to why two signatures are not required for the 13th of June letter.
I accept it is a central part of her reasoning. What I do not accept...
It's alternative.
Well, I submit it is alternative because
But she doesn't say that.
Because you can't decide, just assume she decided it had been a banking operation.
Yes.
Within the terms of those articles. The question then is, do you have to impose two signatures at the earlier stage, at the stage of prior consent?
Well, I suggest anyone reading 321 to 329 would think that she would say yes.
No. Anyone reading the judgment as a whole, including in the very part of the judgment where she addresses prior consent and states expressly at paragraph 246 that an argument was deployed by BNC by reference to the supposed needs for two signatures.
And you say that is encompassing the argument about Article 15?
What it looks as, it says, there is an argument as to whether it's a banking transaction. I will deal with that later. But is there any requirement for signatures at all? And at that stage...
Well, they're actually looking at the handbook.
She's looking at the evidence and the requirements for it, for signatures, and other documents or evidence which suggest that two signatures were ever required for preliminary consent.
Well, I'm afraid I just don't understand how you can say that encompasses Article 15 when she doesn't mention it. I mean, you say that paragraph on its own is a decision that the requirement for two set signatures in Article 15 does not apply as a matter of does not apply to the prior consent when, notwithstanding what she says in 320 and thereafter. I'd have thought you'd at least accept that it's unclear.
Well,
but if you don't accept it's unclear,
well,
then...
my Lord, one of the points I was going to make in due course, but I'll make it right now, is if we could look at paragraph 326 of the judgment. So this is in the section my Lord is directing me to. At paragraph 326 on page 147, the judge is in the process of dealing with Professor Mendoza's evidence. She starts at 325, and then at 326 she says that Professor Mendoza's approach seemed both impractical as requiring a degree of formality, which would be odd in cases where a transaction effectively made no difference to the bank's bottom line, and contrary to the understanding of those operating in the BNC at the time. And then there's this sentence, my Lord. As CRF pointed out, there is no record of any previous in-principle consent to an assignment, or even the confirmation of the finalised assignment being attended with such formalities. And the references to formalities the judge has in mind there are references back to the paragraphs I've been directing your Lordship to, paragraphs, or the court to, paragraphs 227 and 228, the absence of formalities in relation to the prior consent. Paragraph 246, the absence of formalities.
We're only talking about two signatures, are we?
The formality is the need for two signatures.
Well,
yes.
why does that require delay? Why does that amount to delay getting two signatures of somebody in the office?
I'm sorry.
Why would that create delay?
I'm not concerned so much about the delay, my Lord. I mean, there is a delay. You've got to get two signatures.
Why
But that's
is it a formality?
a degree of formality. Having two signatures, a degree of formality.
Well, there's always going to be one signature, isn't there? There's always going to be one, because any email or letter is going to have one signature on. So all you need to do is add one more. But why is I struggle to understand why it's impractical, or is it? I mean, this is all part of this. This is all much too clumsy and impractical. I'd like to know why it is for Miss Marty to also get Mr. Lozano to put his signature on.
My Lord, when the judge is referring to formalities, she's referring to the need for two signatures.
Well, indeed, any signature. The email has no signature in it.
But we can pick that up. The submission I've just made and reinforced by my Lord Justice Arnold, in paragraph 332, just so we don't lose sight of this, what the judge is talking about. In 332, the judge is considering now the November documents and BNC's argument.
Yeah.
What relevance those documents have and what impact any...
Putting the rules aside for one moment.
No, just the bit I'm going to, what matters, what impact any arguments of Cuban law as to formalities have. So when she's talking about formality, the judge is looking at the need for two signatures. And she puts it aside and then comes to a conclusion. And then she deals with the rules in 336 and says they don't apply. But formalities means two signatures. And in her, as part of her reasoning in relation to Articles 15 and Article 12 and Article 17 and the BNC signature rules, in paragraph 326, is that there, as CRF pointed out, there is no record of any previous and principal consent to an assignment or even the confirmation of the finalised assignment, that's the paragraph we just looked at, being attended with such formalities, two signatures. There's no record of it. And the in principle paragraphs, as I say, are 227, 228, 246, 332 to 335. And in relation to the finalised assignment, the relevant paragraphs are the ones I've just taken the court to, 341 and later on 348 Roman 6. All those paragraphs say that no one at BNC attributed any formal requirement for two signatures in relation to in principle or the later materialisation document.
Why does that have any effect whatsoever on the pure question of Cuban law as to whether or not two signatures were required?
Well, the relevance the judge gave it is as a test of
No, but
Professor Mendoza's.
What do you say?
Well, I do. I support the judge's reasoning. It goes to Professor Mendoza points to the BNC signature rules, and he notes that they're directed to banking transactions. And then in his third report, he makes a leap from that, from banking transactions to all actions. Doesn't explain that leap, but that's the leap that he makes. And the judge's criticism is that his reasoning is unclear. It is. He makes a leap. His conclusion presupposes the very notion that he's driving at. So he makes a leap to say that the BNC signature rules don't just apply to, by way of the catch-all provision, all banking operations. It applies to all actions. That's the evidence of Professor Mendoza that's relevant. And the judge says, no, I'm not persuaded by that evidence that the signature rules apply to all actions of BNC, because it's inconsistent with the sea of evidence that is before this court, including all the points that I've made in relation to their lack of formality, their lack of need of signatures.
Well, he must mean by all actions, he must mean all actions in relation to third parties.
Well, I can have a look at how he puts it.
And when he makes a cup of coffee, he's not having to use two signatures.
That's
so
fine.
when he enters something in a bank ledger, you don't use two signatures.
I think his.
But when you're dealing with an external third party, qua banker, when you're communicating with an external third party. Now, obviously, the question is, if you're just writing a letter which has no legal consequences but is expressing views, do you need two signatures for that? It doesn't seem like a banking operation to write a letter, just setting out, please can we have a meeting tomorrow? But any operation where you're writing to a third party, seems to me arguably you do need, that is a banking operation where you might say you need two signatures.
Well, in relation to that point, that particular point, where the dividing line between banking operations and non-banking operations is to be drawn, the context in which the trial proceeded, and this is important, is that it was common ground between the parties that aside from the Foreign Debt Department's responsibility for registering, controlling, servicing, and dealing with historic Cuban sovereign debt, so besides that particular function of handling historic sovereign debt, BNC also maintained certain commercial functions. And that can be seen from paragraph 3 of the amended points of claim. I will go to this document, if I may, just very quickly. It's in the core bundle, tab 11, page 171. Paragraph 3 of the amended points of claim, page 171 of the core bundle. CRF pleaded that BNC had been established as the Central Bank of Cuba and as a commercial bank, and that although the role of the central bank was transferred away in 1997, BNC maintained its functions as a commercial bank. Now, BNC did not fully accept that description, but nonetheless, if we look at the re-amended points of defence on page 186 of this bundle, moving forward to paragraph 6 of the re-amended points of defence, BNC accepted in paragraph 6 that prior to 1997, BNC, was Cuba's central bank with certain commercial functions, and that after the role of the central bank was transferred away in 1997, BNC maintained its commercial functions. So BNC had commercial or banking functions in addition to its responsibility, its specific responsibility for handling historic sovereign debt. That is important context, which so far the judge was aware of, but this court hasn't been. And it's important because there was a big argument about the capacity of BNC to handle Cuban sovereign debt without going to the ministry. And so there was a big focus on the role of the foreign debt department handling foreign debt. And that was a big focus of the case. But one mustn't confuse that separate function under Article 7LL of the relevant decree law, which is conferred on BNC, with the commercial or banking operations of BNC. And when you...
But forgive me, why aren't operations qua central banking operations? If they are operations in relation to banking functions, such as dealing with debt?
Well, I think the answer is that they're no longer the central bank since 1997, but nonetheless, the functions of continuing to perform the functions of handling debt.
Yes.
So simply providing consent to the assignment in the secondary market
Yes.
of debt from one party to another.
Well, Ms. Rodriguez accepted it was a banking operation, did she?
No.
So what did we see? What we were showing the transcript where she appeared to do that.
Well, perhaps I can go directly there. I'm dancing around a little bit, but I'll go directly to that.
The intervention. What I asked you, and what I asked you was, how does one interpret paragraph 321 onwards of the judgment if it is not the judge accepting that there was an issue, a primary issue, which she had to decide as to whether or not two signatures were required by Article 15L. And my question for you is, how does one read those paragraphs other than the judge saying, this is the argument, but first of all, I have to consider whether or not the delegated authority was subject to any requirements under the rules. This is the argument. I find they are not banking operations, therefore two signatures are not required. Now, on the face of it, that is ratio of her decision, which is that two signatures are not required because Article 15L is not engaged because it's not a banking operation. And she does not, at that stage, express any caveats to that, to the effect of none of this is relevant because the signature rules do not apply.
I accept all of that in the sense she does not make the caveat that my lord has indicated.
Well, that's a bit difficult for you then, isn't it?
No, because she's already made that finding.
It's caveated elsewhere.
It is caveat. It is. I mean, one of the principles, of course, I don't need to tell this court, but not to subject the judgment to textual analysis and treat it as a contract or a statute. And our submission is, if you look at the judgment as a whole, it is obvious that the judge has made the finding that I submitted, the first finding. It's not relevant at all. She goes on to consider, because it was argued that it was a banking transaction, and the answer is it's not even that either. And so for both reasons, there is no requirement for two signatures. And that is, it stands out from the judgment, looked at as a whole, and that is how it is understood by those who, on this side of the table, read it. And we submit that is how the judge intended to convey that, having regard to the issues that were in play before her.
Well, whether you're right or not, obviously one we have to consider. But I do say, that to say it's obvious, I have to say, is putting it very high. Because as far as I can see, the key paragraph you rely on is 246. And in that paragraph, she does not reference Article 15. And that's the problem I have with your argument that she has said in that paragraph that two signatures aren't required. That the rules don't apply. She hasn't referenced them. She doesn't say the signature rules don't apply. She's referring there, as I understand it, just the handbook?
Well, she's referring to all the evidence. She's referring to the handbook. I mean, I went through paragraph 246
You
and what
also
she
rely on 335,
I do.
as I understand it.
I do.
Which is after.
I do.
She's considered all the stuff about Article 15.
It is bookended. She's dealing with a specific argument in between raised by BNC, but it is bookended by the first point that I have submitted to the court.
But again, 335 isn't addressing the issue, is it? If there's a requirement for signatures at this stage, i.e. November, it could not affect the validity of the 13th of June consent.
Because there was no requirement for signatures at the 13th of June 2019.
Well, that's right, because she's decided that it's not a banking operation.
She's also decided there was no requirement for signatures.
Well, yes,
But I think
but it's not a banking operation.
we've debated. I've made my submissions. I think
Yes.
the court understands where I'm coming from, that there
Yes.
were two decisions.
Yes.
Looked at fairly, we say, in the judgment as a whole.
I now understand that. I didn't before, because when I asked you whether the real question was whether it was a banking operation, you said yes. But actually, we have two prongs, and I understand that. So I think we must move on.
I do. So what I was proposing to do is, if I can pick it up, I've made the point. So I'm looking now at the appeal, specifically now at the appeal and the paragraphs 3, 2, 1 onwards. And I made the point about the context, different roles between handling sovereign Cuban debt and commercial or banking operations. And I can make very briefly the point that the BNC rules were concerned about signatures and about banking operations. That's obvious from the terms of those rules. And we say they've got nothing whatsoever to do with the separate function, the entirely separate function of handling Cuban sovereign debt, which is covered by the BNC handbook, chapter 6, which the judge set out. So, turning to the particular question, the question for the judge was whether the act of giving consent by BNC to an assignment by a creditor of BNC to a third party amounted to a banking operation within the meaning of the BNC signature rules, so as to have a bearing on how Miss Marty could exercise her authority. And we say, on the assumption, of course, that there had been a requirement for signatures when giving prior consent, which the judge had already found there was not. Now, as to that question, the judge's first stage was to record BNC's case as it had become by the time of closing submissions, at paragraph 322 on page 146. So the first stage is to record BNC's case as it had become at paragraph 322, that the act of giving prior consent to an assignment by a creditor of BNC to a third party was a banking operation. That's what was said for the purpose of Article 12 and 15L. And the judge's last stage was to record her conclusions at paragraph 328 on page 148, that the act of giving consent to such an assignment was not a banking operation within the meaning of either Article 12 and then expressly dealt with it separately, or Article 15L of the BNC signature rules. The main criticism levelled at the judge is that although she correctly identified BNC's case with respect to Article 15L at paragraph 322 and expressly made a finding with respect to it at paragraph 328, she supposedly failed to address it in the intervening 5 paragraphs. And that, with respect, is a most unlikely reading of an experienced judge's judgment. Having identified the case in 1 paragraph and made a finding with respect to it a handful of paragraphs later, the natural assumption and the correct starting point we would submit is that the judge had addressed the case in the paragraphs in between.
Well, we can read what she says, can't we?
Well, may I also submit that that is particularly so, if I may add, where it is plain from 336, just a few paragraphs on, that the judge had Article 15L well in mind. Now, BNC seeks to suggest otherwise, it says that the judge and it says that if the judge had properly had regard to Article 15L, then she would or should have found that the act of giving consent was some other banking operation carried out by BNC in accordance with international standards within the meaning of Article 15L of the BMC rules. So, to be clear, BNC accepts the judge was right to conclude that the act of giving consent was not a banking operation within the meaning of Article 12, and BNC accepts that the judge was right to conclude that the act of giving consent was not a banking operation which was specifically referenced in paragraphs A to M of Article 15. It's not an operation to open a documentary credit or to issue a negotiable instrument or to issue a cashier's cheque or any similar such operation carried out by BNC. Their case is it's some other banking operation in accordance with the international standards carried out by BNC. So BNC make 4 points in support of their appeal in this connection. The first point they make is directed to paragraphs 323 and 324 of the judgment. And at paragraph 323 of the judgment, on page 146, and going over the page, the judge noted that BNC's case depended on equating the act of giving consent to an assignment between a creditor and a third party with a banking operation, and that CRF's expert, Ms. Rodriguez, had expressed the view that the act of giving prior consent to an assignment by a creditor to a third party was not a banking operation caused by the BNC signature rules. The judge then set out a quotation from Ms. Rodriguez's evidence. Now, as to this, at paragraph 18.1 of its skeleton argument, which is in the bundle, core bundle at page 23, and repeated orally yesterday, BNC suggests that the written evidence which the judge expressly considered from Ms. Rodriguez only went to Article 12. That's what they submit. And there is then a reference in their skeleton argument to both paragraphs 323 and 324. That suggestion is, I regret to say, flat wrong. The second paragraph of the evidence from Ms. Rodriguez's written report, which the judge quoted at paragraph 323, was directed to Article 15, not Article 12. The relevant paragraphs of Ms. Rodriguez's report are in the supplementary bundle at tab 19, page 69. The court was taken to them yesterday, so I can take them relatively quickly. But the court will note in the supplementary bundle, tab 19, page 69, that at paragraph 8.48, Ms. Rodriguez expressed the view that the BNC signature rules do not apply to consents to the assignment of sovereign debt, which were within the responsibility of BNC's Foreign Debt Department. Ms. Rodriguez addressed Article 12 at paragraph 8.49, and then she addressed Article 15 at paragraphs 850 and 851, expressing the view that the types of transaction listed in that article do not include the act of BNC giving its consent to an assignment. She drew a distinction between the act of giving consent to an assignment and an assignment itself. And she said at paragraph 8.51.1, in the passage which the judge quoted in her judgment, that the act of giving consent to an assignment is the performance of an existing contractual obligation under an existing loan agreement. It merely permits the existing creditor to assign its existing rights to a new creditor, and she said it does not have any monetary value. And for those reasons, it was Ms. Rodriguez's view that the act of giving consent to an assignment by a creditor to a third party was not a banking operation within Article 15 of the BNC rules.
Well, at least orally, the way the argument was put, that 8.50 does indeed address section 15, but not specifically paragraph L.
Yes, and that's the ground. That's the second ground that I'll come to in a moment. But the first point they make in paragraph 18.1 is that the quotation the judge set out at 323 related only to Article 12, and it doesn't. The judge quoted paragraph 8.51.1, which is directed to Article 15. 15, not 15L, but 15. So we say...
But that's right, isn't it? Because what 851.1 is addressing 12, isn't it?
No, 851, see, it's 8.51. When she talks about the relevant operations, she's looking at the relevant operations that are listed in section 15 of Resolution 1026.
Yes, but her reasoning is that the act of consent without more does not create an obligation.
Yes, and she applies that reasoning. No, that's expressed in 12. She applies that reasoning to Article 15 and the monetary point in relation to Article 15. It's not addressed in paragraph 12 at all. Those are part of her reasons.
Oh, I see the point. What you're saying is you have to read the introductory words. The relevant operations, the word operations is clearly referring back to what's in the preceding paragraph.
Precisely.
Not least because it doesn't appear within paragraph 8.49.
Yes. The second paragraph of the evidence for Ms. Rodriguez's written report, which the judge quoted at paragraph 323, was part of Ms. Rodriguez's explanation for why the banking operations covered by Article 15 of the BNC signature rules do not include the act of BNC giving its consent to an assignment by a creditor to a third party. And that being so, it follows that BNC is wrong to suggest that the conclusions expressed by the judge at paragraph 324 of her judgment, back to page 147 of the core bundle, BNC is wrong to suggest that the conclusions expressed by the judge at 324 on page 147 were confined to Article 12. They were not. In that paragraph, the judge addressed Ms. Rodriguez's evidence with respect to both Articles 12 and 15 of the BNC signature rules, and as a whole. And the gist of the evidence, which the judge described as being that signatures were required for transactions, which equated to an obligation for BNC, and that the act of giving consent to an assignment by a creditor to a third party did not amount to such an obligation for BNC, as there was no amount involved which appeared to make sense to the judge. Reflecting the distinction which Ms. Rodriguez had made in her report in paragraph 8.51.1.
Yeah, so you say that is consistent directly with 51.1.
Yes.
Let me understand this. Are you saying that Ms. Rodriguez's evidence was that the banking operations within section 15, or rather the other way around, section 12 is referring to banking obligations, banking transactions that create an obligation, and that section 15 is enumerating those obligations?
That's part of the way. Whether it is linked or not, it's not. That they're standalone obligations. I'm not saying that they were, but what Ms. Rodriguez's evidence was is precisely this, that whether you're looking at Article 12 or Article 15, you are looking at acts by BNC, obligations for BNC. And what Ms. Rodriguez does in Article 851.1 is to draw the very real distinction, as the judge put it, between executing an assignment of a debt, i.e. between either BNC itself, either assigning the debt to a third party or becoming the assignee of the debt. Distinction between that and the act of consenting to the assignment of a debt owed by the bank between its creditor and another person. What's key is who's doing the assigning. In Ms. Rodriguez's view, whereas the former involved an obligation for BNC, if BNC was doing the assigning or accepting an assignment, that involved an obligation for BNC and was caught by the signature rules. But the latter did not. The substance of her evidence was that the act of consenting to an assignment of a debt between a creditor and another person was not, or did not involve, an obligation for BNC. the way she phrased that, it was an existing contractual obligation under an existing loan agreement, merely permits the existing creditor to assign its existing rights to a new creditor, and that is not a banking operation. That is the substance, was the substance of Ms. Rodriguez's evidence, and it is reflected in the judge's findings in paragraph 324. The second point, as my Lord Justice Arnold made, is that paragraph 18.2 of its skeleton argument. BNC suggests that the evidence given by Ms. Rodriguez in her report and generally do not support the findings made by the judge in 324 because Ms. Rodriguez did not make express reference to paragraph L of Article 15. She referred to Article 15, she referred to a couple of subparagraphs by way of example, but not specifically to paragraph L. That is, we say, a thoroughly unfair criticism of Ms. Rodriguez, given that, as we have explained in our skeleton argument, BNC had not even pleaded Article 15L, and when, in his second report, which is where the point was first raised by Professor Mendoza on behalf of BNC, all he said was that Article 15L applied to all banking transactions, not all actions, and without providing any explanation as to why the act of giving consent to the assignment by a creditor to a third party was a banking obligation. So Ms. Rodriguez deals with
banking operations.
Banking operation. Forgive me. Did I say I'm so sorry. Banking operation. Yes. So we say, but in any event, the submission that Ms. Rodriguez didn't mention specifically paragraph L ignores the substance of her evidence, which was that regardless of whether one is focused on paragraphs F or G of paragraph 15 or any other paragraph of that article, the giving of consent to an assignment between a creditor and a third party was not the sort of transaction which was caught by Article 15 for the reasons she gave, which the judge rightly understood as equating a banking operation within the ambit of Article 15 with an obligation for B and C. What's crucial is who's doing the assigning. The act of giving consent to an assignment by others did not involve an obligation for B and C. Now, Ms. Rodriguez was not taken to the relevant paragraphs of her report in cross-examination, and she was not challenged on the views which she's expressed in those paragraphs, as the judge found. Those paragraphs, therefore, and her evidence as a whole were an entirely sufficient basis on which the judge was entitled to come to the conclusions which she did in paragraph 324.
But were we not taken to passage of cross-examination which suggests she said something else?
I'm coming to that right now. The third point made by BNC is directed to the first two sentences of paragraph 324, where the judge said that a certain amount of cross-examination was directed to the question of whether an assignment of a debt was contrary to Ms. Rodriguez's evidence caught by the rules. The effect of Ms. Rodriguez's evidence appeared to be that she accepted these propositions, at least insofar as they concerned assignments of debts by BNC. However, she was not asked and did not accept the proposition that consent to an assignment between a creditor and a third party was a banking operation which attracted a need for compliance with these rules. And of course, that last bit is the view she'd expressed in her written report. So BNC suggests at paragraph 18.3 of its skeleton argument that the judge should have found that Ms. Rodriguez was not only asked in cross-examination whether the act of giving consent to an assignment by a creditor of BNC to a third party amounted to a banking operation for the purposes of Article 15L, but that Ms. Rodriguez had agreed that it did so. And we say that's quite an extraordinary submission in circumstances where Ms. Rodriguez was not taken to paragraphs 50 and 51 of her report in cross-examination. What BNC relies on instead is a passage in the cross-examination which appears in the supplementary bundle commencing at page 138. So there's a supplementary bundle, tab 29, at page 138. although my learned friend started his analysis of the passage later on, he started, as I recall, on page 53 of the transcript internally, on page 138 of the bundle, at line 13. Ms. Rodriguez was, in fact, first taken to Article 15 2 pages earlier, at paragraph 50 of the transcript, same page in the bundle, at line 6. So this court was shown only part of the relevant exchange in isolation, with the danger that brings with it. Important to the cross-examination which followed is the context which preceded it. So it starts at page 50, line 6, and at the internal page 51 of the transcript, line 6, Ms. Rodriguez was asked about Article 15E first, which specifically identified an operation by B and C to assign, endorse, or order a protest of any bills as a banking operation. And Ms. Rodriguez quite properly agreed that an assignment by B and C was so specified by the rules. And then at page 52, line 3, Ms. Rodriguez was taken to Article 15K, and this is important, which specifically identified an operation by B and C to approve any accounting vouchers and notices related to any of the above transactions, which transactions were necessarily therefore ones to be affected by B and C, and included an assignment by B and C. And Ms. Rodriguez again quite properly agreed that such an operation by B and C was specified as a banking operation by the rules. Then Ms. Rodriguez was taken to Article 15L at page 52, line 13. But the particular passage on which B and C relies comes later, after Ms. Rodriguez had been distracted by an interruption with a technician coming in who had been asked to replace a microphone on the computer equipment through which Ms. Rodriguez was giving video link evidence. I think my recollection is that the technician even popped around and waved at us to show who he was, rather than perhaps a lawyer or someone assisting Ms. Rodriguez. The question actually put to Ms. Rodriguez at page 54 of the transcript, page 139 of the bundle, lines 13 to 17, after counsel for BNC said, "So I'll start again," was, "We were looking at 15L and we were considering the assignment scenario. My question is, if something like approval of accounting vouchers and notices is a banking operation, approval of an assignment is likewise a banking operation, isn't it?" And Ms. Rodriguez asked counsel if he was referring to paragraph L. And he said at line 23 on page 54. And again, this is important. "Well, I am referring to L, but I am also referring to K, which was directed to transactions to be affected by B and C." And as Ms. Rodriguez was struggling to understand the scope of the question that was being asked and had asked to reformulate, if the question could be reformulated, counsel for BMC reformulated the question in this way at the top of page 55 of the transcript, line 1. If under K, something like approval of an accounting voucher or a notice constitutes a banking operation, then it follows, doesn't it, that under L, approval of an assignment would likewise be a banking operation. Counsel, in other words, linked his question to paragraph K.
Well, forgive me, I'm really sorry. But you've missed out paragraph page 53, which comes before the technician's interruption, as you did, where at the top of the page,
Yes.
the witness was asked about, in order for the assignment to be effective, the debtor's approval is required. So can we please make the assumption if approval is given, etc. And then the witness says, I think you were referring to consent to the debt assignment.
Yes.
So it's absolutely plain that she understood what was being talked about.
Well, 2 points. One, she's asking, is that what you mean?
Yes.
She's asking the question to be reformulated.
Yes.
But what that doesn't address, and as I emphasised, or at least sought to emphasise, the key point here is who is doing the assigning. The key point is here, is this an assignment by BNC, or is this an assignment by a creditor to a third party? That is the distinction Ms. Rodriguez had drawn in a report.
Well, she's been asked in the next question, so in that scenario, the giving or withholding of approval to the assignment by the debtor is a banking operation within the meaning of 15L. Do you agree? Answer, it is a banking operation. Now, are you saying that Ms. Rodriguez at that point did not understand that she was being asked about the bank consenting to the assignment?
The words, it is a banking operation, is a repeat of the question. She's not saying it is a banking operation. She's saying it is a banking operation, ... Well, and then she answers, point L is wide.
But
And that's...
whatever one says about 53, it is, I would suggest, it is at least arguably plain that at that stage, she has been quite carefully taken through an assignment to the question of consent to the assignment. She herself has identified that that's what we're talking about here, the actual consent to an assignment. So when we then come on to 54 and 55, it's quite plain that she understands what is being taught about.
Well, my lord, I don't accept...
You can refer to interruptions by the technician to try and undermine it, but the evidence on the face of it seems to be quite clear.
I don't accept that, my lord, at all. The question is, the whole passage starts with 15E on page 51, which is an assignment by BNC.
Yes.
The whole of this section of cross-examination of an assignment by BNC.
Yeah, but we're talking about cross-examination of a legal expert who
We
is
are.
being asked to look at various provisions, and the process of cross-examination is to say to her, well, the consent is needed for all these things. Surely consent to the assignment is it in the same vein?
Well,
Seems a perfectly fair line of cross-examination, and the witness seems to have given quite clear answers to me.
let me make these submissions. What is very clear from the judgment is that the judge who was present paid careful regard to this passage in the cross-examination and also to the transcript of it. That is obvious, we say, from what she says about the expert evidence generally in paragraph 211 of her judgment, page 121, where the judge expressly referred to reading the transcript of Ms. Rodriguez's evidence. So the judge has read this transcript. And it is also apparent from the judge's remarks at 324, page 147, where she was careful to express her understanding that this passage in the cross-examination was, when properly analysed, directed to an act of assigning by BNC.
I'm really sorry. She says at 324, however, she was not asked and did not accept the proposition that consent to an assignment was a banking operation. But at page 53, she expressly says, I think you were referring to consent to the debt assignment. And there are several more references to agreement, approval or agreement to an assignment. And at the end of the day, she says, according to the regulation, yes, it could be considered the same. Now, surely the judge should at least have recognised that on the face of it, she was asked about consent to an assignment, and on the face of it, she did agree that it was a banking operation. And you think on that evidence, on that transcript, it was fair for her to say she was not asked and did not accept the proposition that consent to an assignment between a creditor and a third party was a banking operation. You think that's a fair summary of that evidence, do you?
My lord, we submit that the judge's very careful analysis was not only spot on, but entirely admirable. In the context of the reference to Article 15K, which related to the approval of above transactions by BNC, including an assignment by BNC under Article 15E, which is the very two articles that Ms. Rodriguez was taken to at the very start of this cross-examination. The question asked of Ms. Rodriguez was necessarily directed to the approval of an assignment by BNC and not to the act of giving consent to the assignment by a creditor to a third party. The question asked, with the inherent assumptions made, express, was this: if under K, something like an approval of an accounting voucher or a notice related to any of the above transactions by BNC, including an assignment by BNC, constitutes a banking operation, then Ms. Rodriguez was asked, it follows, doesn't it, that under L, approval and assignment by BNC would likewise be a banking operation. Ms. Rodriguez agreed that approval of an assignment by BNC was...
Sorry, it says, doesn't it, at the top of 55, if under K, something like approval on accounting voucher or notice constitutes a banking operation, then it follows, doesn't it, that under L, approval of an assignment, it doesn't refer to BNC. He doesn't expressly, but you say by inference, well, because he's been talking about K, that's what you're saying.
Exactly. So I should have made clear, I've got red text, so it shows me what words I've added in. I do apologise.
Was the expert re-examined about this?
I don't believe the expert was re-examined about this from recollection. But in a sense...
Well, I can understand you may say that that's maybe how it could be read. But for the judge, to say that this was entitled the judge to reach this clear-cut conclusion, to say, I find that submission surprising.
The atmosphere of the courtroom cannot, in any event, be recreated by reference to documents, including transcripts of evidence. The judge heard this evidence, she read the transcript, she thought about it, she gave some very careful analysis in paragraph 324. She understood that this was all directed to transactions by BNC, she was not being asked, the witness was not being asked about a assignment by a creditor to someone else. And the witness, the expert, was not asked about the paragraphs in her report where she expressly addressed that latter point. We say...
Well, I'm really sorry. I don't want to keep going around this, but page 52, the question was, and then this is a question now to a lawyer. I think we can agree that an assignment involves three parties. Mm-hmm. An assignor, an assignee, and the debtor. Correct? Yes. So that's assumed that in order for the assignment to be effective against the debtor, the debtor's approval is required. So can we please make that assumption? If approval is given, then the obligation that was previously owed to the assigner is now owed to the assignee. So that's the hypothetical scenario I would like you to consider, please. Yes, I think you were referring to consent to the debt assignment. I'm sorry, Mr. Kershey, it could not be clearer.
The hypothetical is clear there. What is the answer that Ms. Rodriguez gave, which plainly showed, which shows that the judge was plainly wrong? There was sniggering from the other side of the room when I said that the words, it is a banking operation. That is a question back from Ms. Rodriguez. That's what the judge was alive to. That's why the judge came to the conclusions she did. It's not the assumption in the middle that's appropriate. It's the question. The answer they rely upon is at the top of page 55, and that is necessarily a question by reference to an assignment by BNC.
Well, I've asked you all. I've gone as far as I can in asking you questions about it.
You can. You have, of course. The fourth and final point made by BNC at paragraph 18.4 of its skeleton argument is directed to the judge's treatment of Professor Mendoza's evidence at paragraph 325 and 326 of the judgment. And at the heart of BNC's complaint is the suggestion that the judge supposedly, once again, addressed the significance of Professor Mendoza's evidence only by reference to Article 12, when it is said by BNC that Professor Mendoza's view that practically all actions come within the scope of the BNC rules was founded not on Article 12, it is said, but on Article 15L. And then BNC refers to certain paragraphs of Professor Mendoza's written reports. But that submission, that Professor Mendoza's view was founded not on Article 12, but on Article 15L, is, I regret to say, again, flat wrong. BNC refers to paragraphs 87 to 88 of Professor Mendoza's second report in the supplementary bundle at page 62. It's tab 18, page 62. But in those paragraphs 87 and 88 on page 62, Professor Mendoza says only that the rules apply to all banking operations conducted by BNC, not all actions. He did not at that stage seek to equate all banking operations with all actions. For that, we have to wait till his third report. And that's the passage, this next passage, the other passage to which BNC refers. On page 77 of the bundle, in Professor Mendoza's third report, it's paragraph 32.1 on page 77. And the particular paragraph is 31, did I say 32.1? It's 31.2. Excuse me if I said that wrong. Paragraph 31.2 on page 77. And it's subparagraph 2, so 31.2.2. And in that paragraph, the professor relied first and in the main on Article 12 in support of his contention that the use of a dual signature is a requirement for all acts and documents issued by BNC. And then the professor relied on Article 50L for confirmation. But that is why the judge quite properly addressed Article 12 in this context, and why BNC's criticism of her is entirely misplaced. The professor's view was based on Article 12 and Article 50, and the judge dealt with it accordingly. So if we go back to the judgment at paragraph 325, the judge recorded at paragraph 325 of the judgment, page 147 of the core bundle, that Professor Mendoza's reasoning as to why the act of giving consent should be regarded as a banking operation came back in part to his approach on capacity, which the judge had rejected. I'll come back to that. And in part to an approach to the BNC signature rules, which saw them as necessarily applying to all transactions of the bank's authorised employees. Now, as to that latter approach, there was no evidence before the court that the act of giving consent to an assignment by a creditor to a third party was a banking operation to which any international standards applied. There was no evidence to that effect. There was only Professor Mendoza's express view that practically all actions of BNC's officials were caught by the rules. But as the judge noted, Professor Mendoza's reasoning was not clear. In equating all banking operations with all actions and documents issued by BNC, Professor Mendoza had simply assumed the proposition for which he was contending without more. Gave no reasoning. The leap Professor Mendoza had made, moreover, did not appear to the judge to be justified by the wording of the rules, although the judge made reference in that paragraph to the fact that, contrary to Professor Mendoza's evidence, Article 12 did not impose a blanket obligation, but applied only to banking operations which created an obligation for BMC, Article 12 being the first and main provision on which Professor Mendoza had relied. It was equally the case that Article 15 was limited to the specific banking operations to which it made reference in paragraphs A to M, and by paragraph L to any other banking operation of the same sort which BNC carried out in accordance with international standards. That the judge fully had this in mind is clear from her findings at paragraph 336 in the context of Mr. Lozano's formal letter of the 25th of November 2019, where she said that that letter also did not fit easily within the scheme of the rules, including expressly Article 15L. The BNC signature rules were concerned with banking operations, but not the giving of consent to an assignment. But the giving of consent to an assignment was not a banking operation. The act of giving consent of an assignment between a creditor and a third party was not part of BNC's commercial function, but part of its separate function of registering, controlling, servicing, and dealing with historic Cuban sovereign debt, to which the BNC signature rules were not directed. At paragraph 326, the judge noted that Professor Mendoza's approach seemed impracticable, and we cover this a little, and to require a degree of formality that was contrary to the understanding. And the next sentence I have submitted, and I'll just again make it very briefly. The next sentence is important. As CRF pointed out, there is no record, and so on. So as part of her reasoning for rejecting Professor Mendoza's evidence that the BNC signature rules apply to all actions, was that it did not fit with the other material in the case. No record of any previous and principal consent to an assignment, or even the confirmation of the finalised assignment being attended with such formalities. So the judge rejects Professor Mendoza's evidence for the reasons I've explained, the reasons that the judge gave in paragraphs 227 to 228, the reason the judge gave in 246, the reason the judge gave in 332 to 335, where the judge, as we've seen, had noted the absence of any requirement for any wet ink signatures on consents in principle. And that sentence was also a reference to paragraph 341 and 348 Roman 6, where, and again as we've seen, the judge noted the irrelevance in practical terms of the absence of two wet ink signatures on the finalised assessment. The judge, in other words, rejected Professor Mendoza's evidence because it was inconsistent with the balance of evidence, the sea of evidence that was before her. Then, for good measure, because she understood that Professor Mendoza's views were in part based on his approach to capacity, the judge noted at 325, as the judge had noted at 325, she repeated a point she'd made in the context of her findings when rejecting that argument on capacity about the absence of formality, even in that context as well. So there's no error in what she was saying. She's addressing both the capacity strand and also the strand about the application of the BNC rules and no formality there. So in the result, therefore, even if there had been a requirement for a signature when giving prior consent, which the judge had already found that there was not, the judge concluded the act of giving consent to an assignment by a creditor to a third party did not constitute a banking operation caught by the BNC signature rules, and for this reason also, therefore, BNC's reliance on the absence of two signatures was misplaced, not only in connection with Ms. Marty's email of the 13th of June, which did not need to be signed at all, but also with respect to Mr. Lozano's formal letter of the 25th of November 2019, as the judge found at 336. Put shortly, the BNC signature rules had no bearing on how Ms. Marty could exercise her authority, and thus they provided BNC with no answer to the validity of the prior consent which Ms. Marty was authorised to give and had given by her email of the 13th of June. So stepping back, therefore, and coming to a conclusion on this point, the criticism levelled by BNC against the judge's rejection of its case as to how BNC employees could go about giving consent to an assignment, we say is wholly unfounded. The judge was entitled to conclude that the act of giving consent to an assignment by a creditor to a third party was not a banking operation within the meaning of the BNC signature rules. But in any event, the judge had found that there was no such requirement for any signatures when Ms. Marty gave her consent in principle. Now, the judge's findings in these connections were made having regard to expert evidence on Cuban law, a system of law with which the judge, as with this court, had little scope to bring her skills as an English lawyer to bear, and the content of which the judge was thus had to ascertain with the assistance of the expert evidence.
So can I ask you the same question I
Yes.
asked Mr. Dubnikov? Why is this an issue of Cuban law at all?
Well,
because it seems to me to be an issue of banking, and in particular, international banking standards. I mean, what L, which is the linchpin of BNC's argument, is all about is banking operations in accordance with international standards. So I'm bound to say what I would have expected the parties to have adduced was some evidence from experts in international banking standards.
well,
But there seems to be none.
no, my lord, and the reason for that is 15L was not pleaded. And so when the question of expert evidence was considered,
Except Article 17 was pleaded.
Article 17.
Sorry, Section 17, which refers to Section 15.
To Section 15 in general,
Generally, yeah.
but not L. And the reason no banking experts were called is because it was not pleaded. It came up in the course of Professor Mendoza giving his expert reports.
Well, Section 12 was pleaded, and Section 12, was it, well, maybe Section 12 wasn't?
Yeah, the international standards points only arises in relation to Article 15L.
No, but banking operations arise under Section 12.
Yes. The whole of the BNC rules refer to banking operations. That was our submission.
It's difficult to divine any evidence as to Cuban law which goes as to what a banking operation is.
Well, that may be right. I mean, the question I think the Cuban experts were being asked is how would a Cuban court interpret banking operations, and whether a Cuban court would find that
Is that legitimate evidence, foreign law evidence?
my lord.
Particularly in a civil law system.
Yes.
Well, it is, because that is the function of an expert, is to say what a foreign court would decide.
Yes.
But the question is as a question of the foreign law, as opposed to a question of something else, e.g., what's banking.
Yes. Well, I mean, insofar as the banking evidence is concerned, I've made the submission. There was no evidence before the court below that an act of giving consent to an assignment by a creditor to a third party was a banking operation to which any international standards applied.
And it was assumed that because we were looking at the BMC handbook and the BMC rules, that it had something to do with Cuban law, and that's how it proceeded.
Yes. 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 I'm conscious of the time. It's coming up to 12 o'clock. I've got to cover. Well, we've got to cover. We've addressed the main issue, ground one.
Yep.
I have. As I indicated, even if BNC had been able to show that there'd been some defect in its giving of prior consent, which affected the validity of that consent, we say that there are two separate answers to it, to BNC's reliance on the invalidity. The first, we say, is that on a proper construction of the assignment provisions in the agreements, the failure validly to give prior consent when requested would have amounted to an unreasonable withholding of consent. And secondly, we say that BNC ratified the acts of BNC officials, as the judge found. As I've indicated, I'll come back to the first of those two further answers at the end of our submissions, for as long as time permits. And Mr. Pearson will address BNC's challenge to the second of those answers in a short while. But first, I propose to deal with the remaining ground of appeal, if I may, which is the challenge to the judge's findings with respect to the notice provisions.
Okay.
So ground 3 of the appeal. So turning then to BNC's challenge by its third ground of appeal to the judge's findings in connection with the notice provisions in the debt agreements. The issue in dispute with this respect was a limited one. And I am going to take some time and show it to the court. And if I may, I would like to start with the particulars of claim, which is in the core bundle at tab 11, paragraph 32 at page 178. So this is the amended particulars of claim, paragraph 32 on page 178 of the core bundle. And CRF pleaded that notice of the said assignments was given to BNC on 14th November 2019, when the notice of assignment and agreement to be bound was delivered to BNC's address in Havana, Cuba. And then at paragraph 34, that was followed with a plea that in the premises, the legal title in the debt agreements was assigned to CRF. That was the starting point in the amended particular claim. In the defence, which is tab 15, and it's on page, I think it's there, is it there?
No.
So sorry, it's in tab 12. I do apologise. It's in tab 12 at page 215. So the re-amended defence, paragraph 32, in tab 12, page 215 of the core bundle. B&C admitted that a copy of the notice of assignment and agreement to be bound was delivered to Mr. Lozano by a Cuban lawyer instructed by CRF, but denied at subparagraph C that such delivery was in accordance with the applicable requirements, and there was an express reference made to Article 20 of the debt agreements. And then at paragraph 46 of the re-amended reply, which that is in the supplementary bundle, I'm afraid, tab 15 of the supplementary bundle, at page 53,
Yes.
so paragraph 46 of the re-amended reply, supplementary bundle, tab 15, page 53, CRF denied that the clauses in the agreements referred to by BNC, that's Article 20 in the debt agreements, apply to the giving of notice of assignment under Section 136 of the Law of Property Act 1925, which is what CRF was stating the notice given on the 14th of December 2019 amounted to. So pausing there, those pleas, therefore, put in issue the relevance of the notice provision in Article 20 to the notice of assignment that was delivered to BNC's address in Havana on the 14th of November 2019. BNC contended that Article 20 was relevant to such notice. CRF contended that it was not. And as we shall come to see, the judge agreed with CRF. But CRF also contended that if the notice provisions in Article 20 were relevant, then those provisions had been complied with, since the notice of assignment that was delivered to BNC's address in Havana on the 14th of November 2019 had been delivered to the place for delivery of such notices under Article 20, because BNC had indicated to market participants that that was where such notices should be delivered. To use the language of Article 20, CRF's case was that BNC's offices in Havana, to which the notice of assignment and agreement to be bound had been delivered on the 14th of November, had been designated by BNC as the address for delivery of such notices. Now, as to the first of those two issues that I've identified, the relevance of the notice provisions in Article 20 to the notice of assignment that was delivered to BNC's address in Havana on the 14th of November 2019. The judge addressed this at paragraph 239 of her judgment. Oh no, I'm sorry, I'm not going there. I do apologise. I'm going too quickly. I'm going to what BNC submitted, and it's paragraph 239 of BNC's skeleton for trial, and that is in the core bundle. Is that right? That's not going to be right. It's going to be in a supplementary bundle. Do forgive me. At paragraph 23.
Sorry, supplementary bundle.
Yeah, I'll start again. I've made a complete mess of that. I apologise. Supplementary bundle, tab 23.
Thank you.
And I'm going to page 93. And I'm going to paragraph 239. I think I've got there, finally.
Yes.
At paragraph 239 of its skeleton argument for trial, BNC submitted that the notice, required to be given for the legal assignment of a shows of action pursuant to Section 136 was, on a proper construction of Article 17C of the debt agreements, a condition precedent to a valid assignment under the debt agreements, with the result that the notice had to be given in accordance with the contractual notice provisions of Article 20 of the debt agreements. That was the case advanced at trial. And it is in this connection, the final sentences of Article 17C, which are of importance and we looked at those, if I could just show those, we looked at those in the core bundle at tab 14, page 227. This is the IBI agreement. And at page 227 of the core bundle, we'll see the assignment provision, Article 17, and it's Article 17C. And we looked at this, and we looked at the first sentences of paragraphs 1 and 2. Now it's the second sentences of these paragraphs that are relevant. The second sentence of paragraph 1, 17C1, states that if, as part of the same transaction, the bank wishes to transfer all or part of its obligations under this letter, that assignment shall be effective when that transfer becomes effective in accordance with paragraph 2. So there's a reference to paragraph 2. And then the second sentence of paragraph 2 states that the transfer shall become effective when the bank has received from the transferee an undertaking addressed to the bank and the borrower to be bound by this letter and to perform the obligations transferred to it. So the only document that was contractually required to be provided for an assignment of rights to become effective, therefore, was an undertaking from the transferee, CRF, which was to be provided to the bank, that is ICBC. Contrary to BNC's case, in other words, there was no requirement under Article 17C for the bank, ICBC, or the transferee, CRF, to provide any document to BNC before the transfer became effective. And the giving of any such notice, accordingly, was not, in fact, a condition precedent to a valid assignment, as BNC had argued. The requirement which did arise as a matter of English law was the requirement under Section 136 to give notice in writing of an assignment to the debtor or other person, in order that it should be effectual in law to pass and transfer the legal rights to the debt or shows in action. And the judge found that that notice under Section 136, or given pursuant to Section 136, rather than under the terms of the debt agreements, did not fall within the ambit of the notice provisions in Article 20 of the debt agreements, the terms of which the judge set out at paragraph 393 of her judgment. This is in the core bundle at page 161. In the core bundle at page 161, paragraph 393, the judge set out the relevant terms of Article 20, which provided each communication under this letter shall be made by telex or otherwise in writing, and so on. And in those premises, as the judge noted at 394, there was a short answer to the unattractive point taken by BNC, that the notice given pursuant to Section 136 had been given in the manner required by Article 20. The judge found that the relevant clauses in the agreements did not, on their true construction, apply to the giving of notice under Section 136. To put the point shortly, the notice provisions in Article 20 were by their express terms confined to communications given under this letter, and the notice given pursuant to Section 136 was not such a notice. Indeed, Section 136 does not require notice to be given by any particular person, and consequently, notice may be given even by an assignee or indeed the legal representatives of an assignee after the death of the assignee. But in any event, even if, as a matter of construction, Article 20 had applied to a notice given pursuant to Section 136, then the judge recorded at 393, paragraph 393 of her judgment, that Article 20 required only that written notice be sent to BNC at the telex number or address and marked for the attention of the person, if any, from time to time designated by that party for the purposes of this letter. In other words, contrary to the case advanced by BNC in its trial skeleton argument, this is paragraph 245.1, it's in a supplementary bundle, I'm afraid again, tab 23 again, and this time page 95. Page 95 of the supplementary bundle. Paragraph 245.1 of its skeleton argument at trial, BNC submitted that a notice had to be given to the initial address specified in the debt agreements, which BNC set out at paragraph 241 of its skeleton argument on page 93. The judge concluded that Article 20 in fact required not that the notice had to be sent to that address, that initial address, but only that notice had to be given to the address designated by BNC from time to time. And as to that address designated by BNC from time to time, CRF's case was that BNC had indicated to market participants that notices were to be delivered to the offices in Havana, at which the notice of assignment and agreement to be bound had in fact been delivered on the 14th of November 2019. And in response to that case, BNC did respond to it at paragraph 245.2 of its skeleton argument at trial, back on page 95 of the supplementary bundle. At paragraph 245.2 of its skeleton argument, BNC submitted that that plea by CRF did not insist CRF because it did not amount to a written variation of Article 20. But it followed from the judge's findings that no variation of Article 20 was in fact required. The question was simply whether there had been a designation. And as to that factual question, as to whether BNC had indicated that its offices in Havana was the address to which notices were to be served, the judge had made numerous findings in her judgment. I'm very conscious of the time, so I will look to try and move through this quite quickly.
Before you do that, I'm afraid I do have to ask you this. You started off by addressing us on section, that the notices under section 136, and took us to the point that therefore that was not a contractual notice. But in your skeleton, at paragraph 76, I understood that you were not taking that point on the appeal.
Do you forgive me? The point I think we were not taking in relation to the appeal, but I'll just remind myself of paragraph 76. Yes, we say that the judge was correct for the reasons she gave.
So you're just simply supporting the judge on section 136?
Yes. So what the judge found is that on a proper construction of Article 17C, there was no contractual requirement as BNC had submitted. And therefore, the Section 136 notice wasn't a notice given under the letter for the purposes of Article 20, and therefore the provisions of Article 20 simply didn't apply to it. We say the judge was right for those reasons. There was no, I took the court to the provisions of Article 17C, which BNC relied upon, and there was no obligation in those paragraphs to provide notice to BNC. The bank there is ICBC, not BNC. So we simply say the judge was right for the reasons she gave.
And so this business actually about designated address doesn't really arise because it's a Section 136 notice not under Article 20
Yes.
or Section 20 or whatever. And accordingly, it's been accepted that it was received hey presto.
That's the first answer which the judge gave, the short answer. But we do rely upon the second answer, that in any event, there was evidence of a designation.
And you sent it there.
I was going to run through the chronology, but I won't because of the time. What I will do is make this submission and go to just 2 paragraphs of the judge's findings. And perhaps I can just draw those up. If I go directly to paragraph 139 of the judgment. And I appreciate I'm jumping in, but there had been correspondence between CRF and Ms. Marty and Mr. Lozano at BNC. And one of the things CRF had done has introduced or informed Mr. Lozano that some Cuban lawyers, Mr. Caballero of Buffete International, would be helping them with the documents. And where I've jumped to in 139 is the findings that Mr. Caballero, so that's CRF's Cuban lawyers, wrote to Mr. Lozano confirming that the CRF documentation was ready for delivery. And Mr. Lozano asked Mr. Caballero if he could attend on the Thursday, and Mr. Caballero confirmed that he could, and the documents were submitted on the 14th of November. And in the next paragraph, paragraph 140 of the judgment, you can see that the following day, the 15th of November, Mr. Gordhandas of CRF sent an email to Mr. Lozano and Ms. Marty confirming that the documents had been delivered as requested by Mr. Lozano. And perhaps I can just go to this document. A copy of Mr. Gordhandas's email of the 15th of November is in the supplementary bundle.
Do we need any more than this set out?
No, we don't. The only point I was going to just show the court, but perhaps take it from me, is that it attached a copy of the assignment, which had on its face the address of BNC, Aguiar 456, between Lamparilla and Amargura. It's on the face of the document.
Right, perhaps you could just give us the reference in the bundle.
Certainly. So Mr. Gordhandas's email is in the supplementary bundle, tab 8, page 29. Mm-hmm. And the copy of the document which is attached is in the supplementary bundle, tab 9, page 30. But what the court will also just see from that email, which went to Mr. Lozano, is the confirmation from Mr. Caballero at the bottom of page 29 of the supplementary bundle, confirming to Mr. Caballero confirms to Mr. Gordhandas that the document has been delivered in BNC today as Ernesto, that's Mr. Caballero, agreed with them. So there's an agreement as to how the document was to be delivered. It was delivered in accordance with that agreement. And that's what the document showed.
Bottom of page 29.
Bottom of page 29, I agree with them. And we say that method of delivery agreed with BNC was standard practice. And that's obvious from the findings we looked at earlier about the sending of the consent in principle emails, where the BNC's debt department asked for documents to be delivered to them. And we say that that standard practice is communicated to and was understood by the market generally. And again, I know I'm taking this quite quickly, but I do want to save time for the other submissions. So I will again jump to important findings made by the judge that this was a standard market practice which had been communicated generally.
What market are we talking about?
The secondary market in Cuban sovereign debt. So it's all those banks out there that trade, or other financial institutions that trade in Cuban sovereign debt. But I can just take 3 points from the judge's judgment. And perhaps if I may, just look at paragraph 14, or note that at paragraph 14 to 21 of her judgment, on pages 76 to 77 of the bundle, when describing previous assignments of the very debt agreements in issue in this case, they were signed previously before they were signed by ICBC to CRF, the judge identifies those assignments and noted that they'd been handled by Mr. Lozano, who at the time was the manager, so Miss Marty's position at the time, and by Miss Lydia Gomez, who was then the director of operations, which Mr. Lozano acceded to. Including, for example, at paragraph 15, the judge makes reference to an assignment of the Credit Lyonnais, from Credit Lyonnais to City and Continental.
But there's nothing here, is there, about delivery and addresses? I don't think.
Well, there is the, again, maybe I can take just this, explain what it is. In the supplementary bundle, tab 2, page 14, there is a cover letter. And over the page, at page 15 of the supplementary bundle, there is the first page of the notice of assignment to which the cover letter referred. And both were sent from, in the case of the letter, and to, in the case of the notice of assignment, the same Aguiar 456 between Lamparilla and Amargura address to which the notice of assignment in issue and this appeal were sent. And that, the court will note, is August 2005. But we get the same point and the same evidence is in the bundles. Likewise, when describing acquisitions of other sovereign debt by ICBC at the instruction of CRF in the period now between 2009 and 2014. Because if we may quickly jump to paragraph 26 of the judgment on page 77 of the core bundle, the judge noted one such acquisition in 2009, which was handled by Mr. Lozano as the manager at that stage and Ms. Lydia Gomez as the director of operations. And another one at paragraph 31 on page 78 of the bundle, an acquisition in November 2013, was handled by Mr. Lozano and now Ms. Magali Mon as the director of operations. And that last one, again, the documents are in the bundle. The cover letter is in the supplementary bundle, tab 3, page 16. And that letter, and over the page at page 17, the notice of assignment to which it referred back in 2013, was sent from, in the case of the letter, and to, in the case of the notice of assignment, the same Aguiar 456 between Lamparilla and Amargura address. And one final reference, if I may, just before I move on. In 2014 and 2015, CRF explored the possibility of having other debt assignments assigned to it, so that they, CRF would hold those assignments in its own name rather than having them held by ICBC on its behalf. Now, neither of those assignments proceeded. The transactions were aborted. But after BNC had consented to them in principle and asked for the documents to be sent to it, and that's what the judge noted at paragraph 46 in the bundle on page 81. On the 20th of June 2014 now, Mr. Lozano and Ms. Marty wrote to Mr. Stevenson and Mr. Gordhandas stating they accept in principle and asking for various documents. And again, those documents are, this time, in the second supplementary bundle. Second supplementary bundle, tab 3, page 4. And what I would ask the court to note is that attached to that email of consent in principle were the templates for some of the documents which needed to be sent by BNC, sent by CRF to BNC, including the indemnity which was asked for. And at page 6 of the supplementary bundle in Spanish and page 7 in English, the templates provided to CRF specified the same Aguiar 456 between Lamparilla and Amargura address to which the notice of assignment in issue on this appeal were sent. So having regard to the totality of the material that was before her, the judge, we say, unsurprisingly found at paragraph 394 of her judgment, 394 of her judgment, page 161 of the bundle, that the notice clauses had been complied with. The notice of assignment having been sent and delivered to the place designated for delivery of such notices, because BNC had indicated to market participants that that was where such notices should be delivered. And we say that is a finding of fact, not rationally unsupportable, not one which no judge could have reached, and is not plainly wrong. It is therefore not one which is open to challenge on this appeal.
Presumably you could just send notice of assignment to the relevant addresses now.
We send it to their current address. I think the point that we make is that the material before the judge show that the address that was actually specified in the agreement dating back to 1982 and 1984 was no longer used. It hadn't been used since at least 2005. And what was used since 2005 in all the evidence before the judge is the address for BNC, where the BNC's debt department sits. And that's the address to which these were, the notice of assignment was sent, as agreed with Mr. Lozano, the Director of Operations, and as everyone in the market, we say, understood was the place for delivery of those. So we say it was sent to the right place. No requirement, but if there was a requirement, it was sent to the right place, as the judge found.
Were these assignments also transfers?
Yes, they were. So they assigned the rights and they transferred the obligations. So they were in the same form as we've seen for the other ones. In all cases, they were both. from 2005, 2013, and the aborted one later on were all to be both assignments of rights and transfer of obligations. So,
And why do you say that the notice of transfer doesn't have to be sent to the bank?
why the notice of I say...
To BNC?
Well, it does, but there's no contractual requirement that it be sent. We obviously want to send it to them, because then it takes effect as a Section 136 notice. And we again get legal title.
Right, but it says the transfer to become effective.
Oh, there. So the bank in that clause is ICBC.
Addressed to the bank and the borrower.
Yes.
It does have to be addressed to the BNC.
The bank, unless I'm very much mistaken, the bank that's been talked about in the debt agreement is ICBC.
But the borrower is BNC.
Oh, it has to be addressed to the borrower. So I see where your lordship's coming to.
What's the point? Addressing must mean sent to.
Well, it talks about being addressed, and the reason that is because then the position as between the assignor and assignee is clear, and there can't be any dispute. But I think it's provided to the bank, although it has to be addressed to those parties, and both those requirements were satisfied. But say that's the first stage. If it did need to be provided, then it was provided as contractually required. So I could go on, but I'm not going to on that point. I'm going to sit down and let Mr. Pearson start to address ratification, if I may.
Thank you. Mr. Pearson, ratification.
Yes. If it please the court will find the second ground of appeal, ratification, in tab 2 of the core bundle, page 15. And there's detail in the subgrounds, but the thrust is in paragraph 2. It says the court was wrong to find that BNC ratified the unauthorised acts of its employees by signing and sending a response or responses to 2 letters before action. Now, this is an attack on the trial judge's 2 conclusions in paragraphs 349 and 350 of the judgment, which is tab 8, page 154 of the core bundle. Now, I'll come on to explain why I say there are 2 conclusions, but for the time being, I invite the court simply to note them. They're as follows. With knowledge of the material circumstances and consent of the Central Bank of Cuba, the duly authorised representative of the BNC, that's Mr. Fernandez, the president of BNC, participated in the discussions in which the letters before action were considered and reviewed and signed the letters in response. By the responses to the letters before action, in particular the second letter, BNC so conducted itself as to show that if it were the case that the assignments had not been authorised, it adopted the transactions and thus ratified the assignment of the agreements on its own behalf. Before I get into my submissions, it's worth pointing out that this second ground of appeal is as important for BNC as it is difficult. BNC must succeed on this grounds in order to be successful overall. Suppose BNC succeeds on ground 1, and the court concludes that Miss Marty was not authorised to consent to the assignments without using 2 signatures. If BNC ratified the assignment of the agreements on its own behalf, that makes no difference. Likewise, if BNC succeeds on ground 3, and the court concludes that there was no legal assignment because BNC wasn't given proper notice, if BNC ratified the assignment of the agreements on its own behalf, that also makes no difference. Now, the ground's a difficult one for BNC because leaving aside a hopeless pleading point and a misreading of part of the pre-action protocol, it's a pure challenge to the judge's findings of fact and assessment of those facts. I doubt it's necessary for me to remind this court of what the rules are when dealing with an appeal against findings of fact. It's a pithy summary, paragraph 52, Deutsche Bank and Vic, which is in the authorities bundle, page 396. Finding of fact can be overturned if it's rationally unsupportable, a decision which no reasonable judge could have reached, or plainly wrong.
What you have to show, forgive me, what you have to show isn't ratification of the assignment, though, is it?
Well,
because the assignment could have been effected without ENC's involvement. It's the consent that has to be ratified, isn't it?
That is true, but the assignment, as my leader has said, is the end of a series of steps, and those steps run through the consent to the assignment. So if you're consenting to the assignment itself, it necessarily follows, if you are ratifying the transaction of which the assignment was the culmination, it necessarily follows that you are ratifying all of the steps which came before.
Does it? I mean, there could be an assignment which you couldn't ratify because you're not a party to it, but to which you haven't consented. So therefore you'd say it was invalid. But you can't ratify the assignment. You can ratify your consent to the assignment.
Yes, I see that. Well, the point is that it was the consent that was ratified.
Well, where? Where does it ratify the consent?
Well, we'll come on to the letters in due course, if I may.
But forgive me, the reason it just occurred to me is because you say that if it's ratified, the notice point goes. But is that right? Because if what you ratified is the assignment can take effect in equity without notification.
Yes.
Why does ratification remove the notice point?
Well, the submission is that because the ratification was of the assignment itself, that encompassed everything which had come before.
You can't ratify the assignment.
I'm right. The ratification is of the consent to the assignment.
Yes.
Yes.
That's nothing to do with notice of assignment.
No.
You haven't, by ratifying your consent, you haven't waived notice requirement. Unless you're going to, that would be an additional aspect that would have to be shown.
I take your lordship's point.
So it seems I had understood that ground 3 arose come what may. What the effect of ground 3 is, I don't know, because it seems to me they could send the notice to the addresses now.
Yes.
Or you could join the, you could join the banks.
Yes.
But the point is taken.
Yes.
And I think where that takes us to is 350, although the language used by the judge is ratified the assignment, in context what she must have meant was ratified the consent to the assignment.
That must be right, my lord.
Well, yeah, except she didn't actually consider whether the wording was apt. The wording which refers to assignment was apt to ratify the consent.
Well, that wording is something that I will come on to.
Yes, I appreciate you said that, sorry.
So that brings me nicely onto the structure that I intend to adopt. First, I intend to take the court through the relevant paragraphs of the judgment. And that's important in understanding how the trial judge's reasoning worked. And it's also extremely important because there are material findings of fact that are not appealed. Secondly, I'll show the court the ratificatory letters themselves and explain why the trial judge's evaluation of them should be allowed to stand. And in doing so, I'll deal with the part of the fourth subground of appeal, which says on their face that the letters can't amount to a ratification. And thirdly, I'll discuss each of the subgrounds of appeal in order. Following the structure that I just outlined, the first thing to deal with is the trial judge's reasoning itself. The relevant paragraphs of the judgment are 345 to 350, which the court will find at pages 152 to 154 in the court file. In paragraphs 345 and 346, the trial judge set out the relevant law relating to ratification. Two propositions can be drawn from the summary of the law. They were more or less undisputed at first instance. They are undisputed on this appeal. They're as follows. First, ratification will be implied whenever the conduct of the person in whose name a transaction has been entered into is such as to show that he adopts the transaction in whole or in part. Secondly,
Well, I think I have to go on. Mere acquiescence may be sufficient.
yes, that's quite right, my lord. That's the first conclusion. The second conclusion is that while the ratifying principal need not know that the purported agent lacked authority, he must know what the purported agent has done and have full knowledge of the material circumstances in which the act was done. Moving on, at paragraph 347, the judge summarised CRF's case. If BNC's employees exceeded their authority by manifesting approval to the proposed assignments without using two signatures, their acts were ratified by Mr. Fernandez, who was at the relevant time the president of BNC. The judge went on to say...
Well, just before you go on,
yes.
In the next sentence, she says the issue is all about the second letter for action, which is the 2020 letter. So she seems to have understood at that stage that it was being accepted by your side that the 2019 letter was not enough on its own.
Yes, that is what she says. While the second letter before action was a culmination of the ratificatory conduct, sent as it was at the end of the chain of correspondence, the trial judge's reasoning in my submission makes perfectly clear that both letters sent on behalf of the appellant were said to be and were relevant. I didn't understand my learned friend to say otherwise yesterday, but if it's necessary to make the point good, the court can have a look at tab 6 of the court file.
Well, yeah, sorry, before you go on, but I thought, the question is whether the 2019 letter is sufficient, or whether you need the 2020 letter as well. The judge certainly looked at both.
Yes.
And on one reading, her conclusion is based on the two taken together.
Yes. And so the question from the court is, do we need to look at both? Is that right?
Well, I thought it was being accepted, and maybe I've misunderstood, that if the 2019 letter wasn't good enough, then the 2020 letter didn't help. But have I misunderstood?
That's not accepted, my lord.
Right, okay, that's my misunderstanding. Thank you for the clarification.
So your position is, in fact, the judge looked at them in combination,
Correct.
but that either or both would be sufficient?
Correct, my lady.
Okay.
Moving on in the judgment. In paragraph 348, the judge said, on this question, the facts as they have emerged justify the following conclusions. There are 11 conclusions in the subparagraphs that follow. Before looking at those conclusions, I invite the court to note two things. First is that the trial judge said the facts as they have emerged justify the following conclusions. The subparagraphs that follow set out conclusions based on the evidence. They're not a run-through of all of the evidence that the trial judge had seen and heard in the course of a 10-day trial. And they don't purport to set out all of the evidence that supported those conclusions. The second is that those conclusions are a first stage of the analysis, not the end of it. As the court will see over the page, there's a second stage set out in paragraphs 349 and 350. In those paragraphs, the trial judge reached evaluatory conclusions in light of the first stage conclusions which she reached under paragraph 348. I'll come on to those evaluatory conclusions. Now I simply invite the court to note the structure. Staying for the time being with the conclusions drawn at the first stage then, I'd like to show the court what is and is not in issue on this appeal. The first three conclusions can be taken together. 348.1 says, after BNC received CRF's first letter before action in its proceedings, I'll come on to the letter itself, the President, on the instructions of the Central Bank of Cuba, convened a working group with a view to drafting a response. 348.2 goes on, the Central Bank of Cuba was involved because it, per Mr. Fernandez, is the entity that establishes and controls policies relating to the problem of Cuban debt, and any matter that's related to Cuban debt has to be mentioned to the BCC. 348.3 then says the working group either included or was attended by 3 senior representatives of the Central Bank of Cuba, and they're named, as well as Mr. Fernandez, who's the head of BNC, the president of BNC, Ms. Alvarez, the incoming vice president, also of BNC, Mr. Lozano, director of operations at BNC, Ms. Marty, heard about her, and Mrs. Ubeldia, who was the legal secretary of BNC. Mr. Ovidio Perez Fong, the BNC general director of operations, was also involved. This lineup is, in my judgment, significant. This is an extensive list of serious senior people, speaks of a determination to deal with the letter carefully. Mr. Fernandez's attempts to distract from this list by suggesting the response was really put together by Messrs. Lozano, Marty and Zabeldia were not impressive. Now, those conclusions are the focus of the first subground of appeal. My Lord Arnold asked yesterday why this finding of fact mattered. My Lord pointed out that the words "and the consent of the Central Bank of Cuba" in 349 of the judgment could be deleted without really making any difference to anything. And that's right, but the finding doesn't simply go to that. The trial judge relies, in paragraph 348.3, upon the presence of serious senior people from BCC and also from BNC as speaking of a determination to deal with the letter seriously. And that was part of the reasoning that led to the trial judge's conclusion in the following paragraph, that the working group reviewed the assignment documents, including the 13th of June email. And the point being made by the trial judge is that the responses to the letters before action weren't hastily dashed off. They were poured over by serious senior people. It would be most surprising in that context if the whole file wasn't reviewed. But my Lord's point is a good one for another reason. There's no appeal from the trial judge's reliance on the presence of serious senior figures from BNC itself. And their presence alone, I would submit, be sufficient for a rational judge to conclude that there was a determination to deal with the letter seriously. Now, before I move on to the next paragraph, I simply point out that the judge's finding isn't said to have been wrong. It simply said that the court should have ignored the involvement of the Central Bank of Cuba because it wasn't pleaded. The next conclusion, in paragraph 348.4, is as follows. Unsurprisingly, therefore, I conclude that the working group reviewed the assignment documents. This was, as Mr. Fernandez accepted, an obvious first step to take. The hotly contested issue was whether this review extended beyond the underlying loan documentation and the letter of the 25th of November and into the wider assignment documents, including the letter of 13 June. Here I conclude that Miss Marty's evidence in the Cuban criminal proceedings is to be preferred to the denials of the witnesses called in these proceedings. Miss Marty said that Raul, that's Mr. Lozano, the director of operations, sent me to ask for the originals of the deposit agreements from the Italian Banking Institute and Credit Lyonnais in Holland. He asked me for the documentation, and that we checked, everybody checked the documents. That is clear, credible evidence. Mr. Fernandez's contention that charged with drafting a formal response to a letter before action, he didn't read any documentation relating to the assignments, he didn't conduct any analysis, is, I regret to say, not credible. Likewise, his oral evidence that he assumes that people who were subordinate to me would have checked the documents. This was not credible as live evidence, and it does not improve on rereading the transcript. The same can be said for the studied attempts of Ms. Zubeldia, Mr. Lozano, and Ms. Alvarez. The evidence on this point was awkwardly given and did not speak frankness. Now, this conclusion is the focus of the second subground of appeal. It said that the judge was wrong to conclude that the 13th of June letter was reviewed, and that instead she should have accepted the evidence that she described as being not credible, studied, and so on. And she should have ignored the evidence from the Cuban criminal proceedings because it was hearsay. It's also said that the judge misinterpreted the evidence from the Cuban trial. Importantly, there is no challenge to the finding that the working group reviewed the underlying documentation and the letter of 25th of November by which Mr. Lozano purported to give final formal consent to the assignment. I'll come back to that. Then the trial judge's next conclusion in 348.5. Whether or not the 13th of June email was itself checked, Mr. Fernandez was aware that a preliminary consent had been given as a foundation for the later documents, and that Mr. Lozano had purported to consent to an assignment by signing the letter and notice of assignment. Others of the working group would also have been aware of this point, and many of them, familiar with the BNC handbook, would know the nature of the response which had been given as a precursor to this letter. Now, this is a very important paragraph because the conclusion of fact, in fact, the several findings of fact, are not challenged. The only challenge in the third subground is to something which it leaves implicit. The implicit point is that in order to have full knowledge of the material circumstances in which the act was done, Mr. Lozano did not himself have to read the 13th of June email by which prior consent had been given. It was enough that, here are the unchallenged findings of fact, he knew that prior consent had been given. Other members of his working group also knew that prior consent had been given. Other members of the working group knew the nature of the response, including, of course, Ms. Marty, who drafted it, and he'd read the formal letter and the notice of assignment to which it led. Now, those unchallenged findings of fact, which led to the trial judge's implicit conclusion, weren't mentioned by my learned friend yesterday. Take the next two conclusions quickly. They're in 349, 6 and 7. They're not challenged. They're not directly relevant to ratification. They're in this section of the judgment because they're factual conclusions which arise from the evidence about the working group.
What seems to be quite an important question is, what was Mr. Fernandez's knowledge of what was required by way of consent? My understanding is the judge has found, hasn't she, that the bank and their officers didn't think that 2 signatures were necessary.
That's right, my lords.
So on this basis, everyone was acting under a mistake because they didn't know that they hadn't given consent.
No.
Yes, I'm sorry. It's pointed out to me that I've got that completely wrong, my lord. 348, subparagraph 6. If, as it is accepted, if as BNC contend, everyone knew about the 2 signature requirements.
Oh, but that was for the 25th of November, because that's in the handbook.
Yes.
I mean, it's your case. Your whole case is the handbook doesn't show there's any signature required.
Yes.
But, of course, this ratification is on the hypothesis that, contrary to that, 2 signatures were required because of 15L. Now, that's a fact, then, that nobody knew about. So it seems to me that I have difficulty with how you can ratify a lack of consent when you didn't even realise there was a lack of consent.
Well, if I can take my lord back to the summary of the law, which is in paragraph 346 of the judgments.
Yeah.
The ratifying principal needs to know what the purported agent has done. So the judge found that Mr. Fernandez knew that there had been a prior consent. Also, in this paragraph, it said that the ratifying principal need not know that the purported agent lacked authority.
But they do have to have full knowledge of the material circumstances in which the act was done.
Yes.
And they didn't know that, in fact, section 15L meant that there had to be 2 signatures.
But that point only goes to whether or not there was authority to give the consent. So therefore it's into knowing that the purported agent lacked authority.
Well, it's slightly difficult to see how understand how those two principles fit together, isn't it? You have to have full knowledge of the material circumstances, but you don't need to know that he lacks authority.
Well, I think the point must be that the lack of authority is not itself a material circumstance. The material circumstance in my submission is what was done.
I think you must mean consent. So I think what you're saying, and correct me if I'm misunderstanding, is that what must be ratified is the consent.
Yes.
And on this hypothesis, there was consent.
Yes.
But there was a lack of authority because the person who gave the consent didn't provide two signatures. And so that's why you say that that's of a lack of authority rather than a want of consent.
Correct, my lord.
I find that slightly difficult because if they didn't have authority, then BNC didn't give consent.
Well, if they didn't have authority, the consent itself was still given, purportedly on behalf of BNC. And it's that purported consent which is subsequently ratified.
And you don't mean ratification unless you've got a purported consent in the beginning.
Correct. So I was very quickly dealing with 349, 6 and 7. My learned leader dealt with them as relevant earlier.
All right, but can I ask you a different question about 6 and 5 and 6?
Yes.
Because the focus there seems to be on the consent in November and the fact that that was defective because, arguably, because of there was one signature and not two.
Well, I'm not sure whether I've understood the question correctly. Paragraph 5 starts with the words whether or not the 13th June email was itself checked. I may have misunderstood the question here.
Oh, I see. So you're focusing on the next words. Mr. Fernandez was aware that a preliminary consent
Correct.
had been given as the foundation for the later documents.
Correct.
Okay.
And the later document of the 25th of November
Yeah.
letter.
All right.
So you're saying, and I had understood little 5 to be focused on the 13th of June email, and what's being said is even if it wasn't specifically checked, it would have been understood by Mr. Fernandez that there was a preliminary step which had been taken.
That's correct, now, my lady, and in fact was understood by Mr. Fernandez. That's the
Yeah,
finding.
that's what's the finding. Yeah.
It doesn't matter whether the 13th email was checked, because they wouldn't have appreciated anyway that it didn't amount to consent.
Well, that rather depends, my lords, on whether the material circumstances are the fact that an act was done, that a purported consent was given, or the material circumstances are the fact that the purported consent was not authorised. And the summary of the law, which is contained in 346, and which is not disputed on this appeal, says that it's the former.
Yeah, and that's in the middle of 346.
Yes. The final 4 conclusions were as follows.
So we're now at
I'm so sorry.
8.
Correct.
8, 9, 10, 11.
8, 9, 10, and 11.
Yep.
I think, to save some time, I'm not going to read that out in full because we'll come back to the correspondence. The only bits that I need to show to the court is the bit at the end of subparagraph 10. As such, it confirmed and adopted the assignments on behalf of BNC and Cuba. The 4th subground of appeal questions that conclusion, questions the conclusion that the resulting letter confirmed and adopted the assignments on behalf of BNC and Cuba. Other than that, the conclusions reached in those paragraphs are not challenged, understandably, because they are essentially recitals from the documents. And the court will recall that I said there are first and second stage conclusions. That was the first stage. The trial judge drew together those first stage conclusions in order to evaluate whether the legal requirements for a ratification had been established. Now, my learned friend's submission, paragraph 350 of the judgment, amounts to a non sequitur, springs from, in my submission, a misunderstanding of what the trial judge was doing in paragraphs 349 and 350. The court will remember that the trial judge had, in 345 and 346, quite rightly noted that there were two relevant English law requirements for a ratification. The one identified at 346 was that while the ratifying principal need not know that the purported agent lacked authority, he must know what the purported agent has done and have full knowledge of the material circumstances in which it was done. And that's what we've just been talking about. Paragraph 349 deals with that particular requirement for ratification. It draws together the conclusions set out in paragraph 348, 1 to 4, to reach the following evaluation. It follows that with knowledge of the material circumstances and the consent of the Central Bank of Cuba, the duly authorised representative of BNC participated in discussions in which the letters before action were considered and reviewed and signed the letters in response. The other requirement for a valid ratification, noted by the trial judge in paragraph 345, was that ratification will be implied whenever the conduct of the person in whose name a transaction has been entered into is such as to show that he adopts the transaction in whole or in part. In paragraph 350, the judge evaluated the first stage conclusions set out at 348, 8 to 11, to reach conclusion on that separate point. She held that by their responses to the letters before action, in particular the second letter, BNC so conducted itself as to show that if it were the case that the assignments had not been authorised, it adopted the transactions and thus ratified the assignment of the agreements on its own behalf. So 350 in my submission is not a sequitur from 349. Rather, the two paragraphs deal separately with the two relevant requirements for a ratification under English law. My next section is the ratificatory conduct itself, but I wonder whether that might be a convenient moment to break rather than getting part way into a new section.
How long was it going to take you?
You've probably still got a few minutes, bearing in mind that.
Exactly, because it's 6 or 7 minutes to
Oh,
run.
of course, I forget about that.
That's what I'm just thinking.
So having looked at the part of the judgment under appeal, I move on then to the conduct that was found to be ratificatory. And the court was showing the relevant letters by my learned friend, but the relevant words weren't actually drawn out. The story starts with CRF's letter before action, which is in the supplementary bundle at tab 10. If the court turns the page, we'll see the paragraph numbered 1. It says, by letter dated 25th of November 2019, BNC confirmed its agreement to a notice of assignment dated 13th of June 2019, by which ICBC Standard Bank PLC Limited assigned to BNC Cuba's assigned 2 of BNC Cuba's debts to CRF. And the court will see from that this very first letter in the chain of correspondence placed the consent to the assignments front and centre. It's the very first numbered paragraph. It then goes on to identify the relevant debts in the subparagraphs and to demand payment. The response is in the next tab, starting substantively on page 37. The first 2 paragraphs say as follows. We refer to your letter of 11th of December 2019 regarding the assignment of receivables executed by ICBC Standard Bank PLC in favour of CRF I Ltd, concluded on the 25th of November 2019. In relation to this matter, as you must be aware, these assignments correspond to debts that the Banco Nacional De Cuba has had on its records since the 1980s, with no partial or total payments of principal or interest relating to them having been made. Now, there might be room for doubt as to whether the first paragraph is simply identifying the letter with the words regarding the assignment of receivables, but not in my submission much. The second paragraph leaves no room for doubt. It refers to these assignments, which is consistent only with there having been a valid assignment. Indeed, the rest of the letter is premised upon there having been an assignment. The next paragraph goes on to mention a pari passu clause in an unrelated refinancing agreement and says in its last sentence that, due to the aforementioned clause, it's not appropriate for Cuba to establish bilateral negotiations. The BNC is saying that it can't pay, not that it's not obliged to pay. The excuse takes as its premise that CRF is a creditor of BNC and therefore has taken a valid assignment of the agreements. The letter then continues in the same vein. The next paragraph also speaks of the pari passu clause, and then there are 2 paragraphs pointing to Cuba's economic situation. Again, those explain why BNC can't pay, rather than saying that it's not obliged to pay. After this, there's a second letter before action from CRF, which starts on page 40 of the supplemental bundle behind tab 12. And this is merely part of the background when it comes to ratification. It is, however, worth the court bearing it in mind when it comes to the submission that my learned friend made, that CRF was an irresponsible creditor bent on immediately commencing litigation. The first 3 numbered paragraphs of the letter over the page say as follows. 1. Your letter refers to the fact that the debts described in the LBC have been maintained in BNC's records since the 1980s with no payment ever having been made by either BNC or Cuba as guarantor. Notwithstanding these circumstances, as you know, CRF has since 2013 been seeking to resolve its outstanding debt claims against BNC and Cuba, including but not limited to the debts. CRF has approached BNC and Cuba on multiple occasions in relation to these matters, but has received no response. Furthermore, CRF has led the efforts to form the Cuba Ad Hoc London Club Committee. The London Club has also reached out to BNC and Cuba on various occasions, most recently in January 2018, making detailed proposals to restructure and resolve BNC and Cuba's
Where does this go, Mr. President? It goes...
So this doesn't go to ratification.
No, it perhaps goes to some of the submissions made by Ms MacDonald about economic...
It goes to them.
Yeah.
Yes, and I think you've got the message.
I have, so
I will
let's
stop
move on.
reading it then.
Yeah.
Now, the response to this from BNC is in a very similar vein to the first, but it's even clearer in my submission. The first paragraph says, we refer to your letter, it's on behind tab 13, page 43. The first paragraph says, we refer to your letter of the 14th of January 2020, in which you raise aspects related to the assignment of receivables executed by ICBC Standard Bank plc in favour of CRF I Ltd, and propose some terms to respond and settle the debt. As with the first letter, it might be said that there's some doubt as to whether this merely refers to and summarises the preceding letter, or whether it actually proceeds on the basis that there was an assignment. The reference to the assignment rather suggests the latter. The following paragraph, however, makes it clear beyond doubt. It says, in this regard, as stated in our letter dated 30th of December 2019, we reiterate that the assigned receivables, or those signed bilaterally, under short-term bank non-trade related indebtedness, are under the umbrella of the 1984 refinancing agreement. It is, I would submit, impossible to read the words assigned receivables as meaning anything other than that the receivables in question have in fact been assigned. And the receivables in question quite plainly are the agreements. Just to make that point good, the court will see that they're said to be signed bilaterally under short-term bank non-trade related indebtedness. I don't need to go there, but I will just tell the court for its notes that behind tab 12 in the core bundle is BNC's defence. At page 188, paragraph 8b, BNC describes these agreements as being just that, and there's an identical statement in relation to the other agreements in paragraph 10b of the same document. Now, there I think I probably am, my lady, at time. So perhaps I can pick this up after the short adjournment.
Thank you. And you're doing reasonably well?
Yes, my lady.
Thank you. 2 o'clock then.
All right.
On purpose.